Hi, everyone. Welcome to today's webinar on perceptions about arbitration practice from the US and Singapore. I'm Adriana Usan, SIC's Head of Americas, and I will be moderating today's webinar in my capacity as both a young SIC committee member and a part of the Chartered Institute of Arbitrators Young Members Group in Singapore, or CIArb YMG. Before we begin, just a few words about these two groups. YSIC is a worldwide arbitration network that, among its many activities, provides a platform for young professionals and students to connect, learn more about SIC, and exchange ideas and knowledge about international arbitration. The YSIC community has now grown to over 6,000 members from 125 jurisdictions. CIArb's YMG also brings together dispute resolution practitioners and students below the age of 40 interested in building their careers in ADR. YMG likewise offers a variety of events, trainings, and workshops. So if you're not yet a member, please do join us. It is a lot of fun and you get to meet new friends. So today, YSIC and CIArb YMG brings you an exciting session. We are very fortunate to have Associate Professor Darius Chan, Professor of Law at the Singapore Management University. He is also an advocate and arbitrator at Fountain Court Chambers, as well as a counsel at Breakpoint LLC. Justin Rassi, also a YSIC committee member and an associate at Debevoise and Plimpton in New York. Samantha Tan, also a part of CIArb YMG and a senior associate at Freshfields in Singapore. And Kirsten Teo, a special legal consultant at De Almeida Pereira in Washington, D.C. She is a CIArb member and the global lead ambassador for arbitration intelligence. Hi and welcome, everyone. Please make yourself comfortable. This is going to be a casual conversation. And for our viewers, this is an opportunity for a meaningful exchange. And so to advance the dialogue, please do use the chat feature and the Q&A box to share your thoughts or stories and ask questions. Now, to allow our viewers to get to know our speakers on a more personal level, I would like to ask our speakers to please say something interesting about yourself outside of your arbitration practice before answering your first question. So I will start with Kirsten. So Kirsten, please tell us something interesting about yourself outside of arbitration.
Sure. It was a struggle to figure this out, but I like to say that I do have a profound interest in the law of the air and law of the sea. And the reason behind this is because when I was 18, graduating from college, I was thinking, what should I do with my life? And I was shopping with friends in a mall, and there was a long line, and I thought it must be something good, right? So many people are lining up to get this, I don't know, prize. And we lined up, and I realized at the end of the line, it was actually a Singapore Airlines cabin crew recruitment drive. And I was like, well, I stood in the line for so long, I might as well try it out. And I made it all the way to the interviews, the final stage of the director of the SQ. And I almost, joined SQ, and I almost did not become a lawyer. But it was really nice of the director to tell me, as a, in terms of personal advice, that she would have favored me going to law school. So she said that she thought I should go to law school instead of, joining Singapore Airlines. And so I never really lost that interest in aviation or law of the sea. And so I decided to specialize in those two areas in addition to arbitration. So that's the story behind it.
Thanks, Kirsten. Well, we're glad you pursued law, or else you won't be with us here today. So I thought to ask you the first question because you have the benefit of practicing arbitration both in Singapore and in the US. And Singapore, as you know, and as the recent White and Case International Arbitration Survey shows, has established itself as one of the leading hubs for international arbitration with its arbitration-friendly legal system, complemented by a robust litigation framework. And Singapore is now in fact, ranked alongside London as the leading seat of arbitration in the world. So, Kirsten, you have worked in Singapore for a decade and in the US for a couple of months now, or was it a couple of years now? And in your view, is arbitration currently the preferred commercial dispute resolution mechanism in the US?
Right. So the US is really a huge country, and it depends really on whom in the US you ask. It's a general counsel's conundrum whether to arbitrate or to litigate in court. the conventional assumption has been that arbitration promised to be superior to litigation because of confidentiality, presumed cost savings, expeditious results, expertise of the arbitrators, and flexibility in the procedure. So the question is whether the promise of arbitration is real or illusory. So depending on the case at hand, that promise is sometimes real and sometimes illusory. And if you speak to some general counsels here in the US, you actually have to discuss the benefits of arbitrating instead of litigating. Whereas I felt that in Singapore, I didn't really have to do that. It was sort of known that arbitration was the go-to or the first port of call when it comes to dispute resolution. I would say that arbitration is preferred by US companies that view it as a manageable and efficient mechanism for resolving disputes with commercial entities, while avoiding time-consuming, costly litigation. Corporations also like to limit discovery, set their own rules for presenting evidence, schedule proceedings at their own convenience, and select arbitrators with certain specializations who can then decide their cases. However, when arbitration does not end up being cheaper, expeditious, or it proves to be less effective for certain types of disputes, perhaps say technology or IP or blockchain disputes, or when the parties face challenges in, for instance, bringing third parties, non-signatories into the arbitration, even though in reality, these are relevant parties to the dispute, arbitration then perhaps becomes less appealing to them. So I would really say it's a mixed variety of responses to arbitration. And I've also encountered general counsels who actually in their personal capacity really prefer arbitration, but in their line of work for these MNCs, they're not in a position to include arbitration clauses in their contracts. So I would say the best is yet to be. We have a long way to go. And perhaps for some companies, arbitration is a shoo-in and for others not. But that's where we have to work towards making the benefits of arbitration real to them. So.
Right. Thanks, Kirsten. So there's a lot of work to be done in the US based on what you just said. So let's also hear from our viewers. What is your preferred dispute resolution? Let us know by answering the poll question on your screen right now. Okay, that's very interesting. So I'm not sure if the other speakers can see this, but so arbitration is #1 based on our attendees' votes. Thank you very much for your participation. Turning now to Sam, even if this poll question shows that arbitration is the preferred dispute resolution mechanism, but as what Kirsten just said, it's still a long way to go in the US. Sam, what do you think can arbitration lawyers do to make their clients more comfortable with arbitration?
Thanks, Adriana. Should I start with something interesting about myself?
Of course.
Yeah, I mean, it's not all that interesting, but let's just get it over with. Well, just to tell our viewers, for the past month or so, I've been suffering from some finger pain. And that I promise you, that's not the interesting thing about me. But it's because I started picking up the guitar. And, it's a pretty late stage, I think, to learn an instrument. But it's something that I've been trying to do. I have no ambitions of becoming some kind of rock star. All I really want to do is become a competent campfire singer, strummer. And so that's just something that I've been doing in my free time. It's quite a good hobby, I think. You can do it, for 5 minutes, 10 minutes before you go to bed. So I've been really enjoying that. Anyone who has any tips on how to learn at this late stage in my life, I would be very grateful. So turning to the question, what we can do to make our clients more comfortable with arbitration. I would say 2 things. I would start with an optimistic note, and I would couple it with a dose of reality. What do I mean? On the optimistic note, I would share with clients our success stories. In other words, it works. Arbitration works in 2 ways, I think. First, it's possible to go all the way and win. Countless awards we've heard of in the public sphere, most of these are investment treaty awards, have been awards of $1 billion, more than billions of dollars, against, I'll say a lot of them are Latin American states. For example, ConocoPhillips, Rosero Mining, these are American, Canadian investors, and they actually recover substantial awards against states through arbitration. There are, of course, many more examples of successful outcomes in commercial arbitrations, but most of them are confidential, so I can't give you that many examples. The other way in which I would share with the client that arbitration works is that it's possible even not to go all the way and still win. So we've got many examples where arbitration has been used as leverage. Generally, clients can feel comfortable using arbitration as leverage, filing a claim or threatening to file a claim if necessary, without, so much alienating the other party as you would if you had to file a public litigation and everybody knows that this counterparty of yours has been sued. So I think this is a really good tool for clients to use where they've got a dispute with their counterparty. The second thing I would do is critically manage our clients' expectations. There are a few aspects to this, and I'll just name two of them. First, time. I think a lot of frustrations with arbitration recently has been that it's taken longer than is expected. The original promise was that arbitration is efficient, quicker than litigation. But I think we have to appreciate that the larger commercial arbitrations that we see today sometimes can take as long as a litigation could take in certain courts. So we have to let our clients know that it takes time because we're resolving a dispute fairly and thoroughly, but you've got to then compare that with the prospect of litigation in whichever local courts your dispute might end up with. The second thing I will manage a client's expectation on is money. Two aspects to this: legal costs, lawyers' fees, and second, the award that you get, the monetary award. So I would tell a client that yes, arbitration can be expensive, but if you think about your dispute, your lawyer's fees might not be all that different from the amount you spend in a litigation. And for the legal costs that you spend in arbitration, you get an award that is more valuable than a court judgment. Arbitral awards tend to be more readily enforceable in more jurisdictions than most court judgments because of the New York Convention. You've got 168 countries now that are parties. It's pretty unlikely that any one of your local courts is going to have reciprocity with other courts to this extent, where you can take a court judgment and enforce. And so just related to that point, I'll finish off. In order to, if a client were to have a better experience with arbitration, I would encourage them to have properly drafted arbitration clauses in their contracts, preferably incorporating well-drafted arbitral institutions rules. And here, I'll plug for YSIAC's rules, which are very comprehensive and they work. So clients' frustrations with arbitration often can be traced to a lack of clarity in the procedure, and having well-drafted clauses in your contracts right at the beginning can help.
Thank you, Sam. I just want to ask a follow-up question on your point that, which I found really interesting, which is managing your clients' expectations by letting them know their costs and what they should expect in an arbitration. Did you find, based on your experience, that clients would change their mind after managing their expectations?
I mean, I think by the point where we are talking to a client about how long things are going to take, how expensive, they already have the arbitration clause and they have to, you have to use it. But I think it would help them to not at the end of the process decide, I'm never going to do this again. I mean, I do have clients who tell me, I really had a bad experience with arbitration, happily not with our firm, but previous experiences, and they really don't want to do it anymore. And I think we need to help our clients understand through the process that, you know, there are some realities to a proceeding, similarly to a litigation, so that at the end of using arbitration, they're not frustrated and decide to default back to what they might be more used to.
Right. So I'm also interested to know from our attendees why you would prefer arbitration. Please let yourself be heard by answering the next poll question. Thirty more seconds. Okay, great. Thank you so much for voting. This is very interesting. So I'll read the top three reasons. So first is enforceability of awards worldwide, the New York Convention. The second would be the party's ability to select arbitrators. And the third, there's a tie for confidentiality and neutral forum. Okay, that's very interesting, guys. Thank you so much. All right. So when we mention ADR, we immediately think of arbitration, but that seems to be changing. And I'd like to ask Darius for his views on the future of other ADR mechanisms in Singapore. But first, something interesting about yourself, Darius.
Sure, and a very good morning, everyone from Singapore. On the interesting thing about myself, I'm thinking back to my very first cross-examination. It wasn't in an arbitration matter, but in a 2-week gang rape trial where I was acting as pro bono defense counsel for one of the 5 young accused persons. And the entire experience from going to the prisons and having to cross-examine the medical expert as a young lawyer ranks as one of the most daunting yet memorable trials I've ever done. Right? And on that note, we segue to ADR mechanisms. And I think a lot of limelight is now placed on the Singapore Convention on Mediation, which is touted as mediation's equivalent of the New York Convention. Some of you might not be aware of this, but the genesis of the Singapore Convention has been attributed to a proposal by the US during a Windsor Trial Working Group meeting. I think there are now more than 50 signatories, including the US. 6 signatories have ratified the convention. But leaving aside the actual take-up rate of the Singapore Convention, I think the most important achievement of the convention is what I would call the publicity effect, such that at least in Asia, mediation has been seared into the consciousness of most practitioners. And the question is not so much whether to negotiate or mediate, but the real question, as Sam alluded to, is how do we get the client to the best position to broach mediation or negotiation? How do we get the leverage for the client to ensure an optimal negotiation or mediated settlement outcome?
Right. Thanks, Darius. Justin, I will now go to you. From your side, what do you think is the future of other ADR mechanisms in the US?
Well, I think at the moment, interesting fact about me. An interesting fact about me is when New York was locked down last year, I enrolled in an online pastry chef course to keep up my skills. Nice. Not that I had pre-existing pastry skills, but to keep up my cooking skills. And I can now work my way around the pastry kitchen. The future of the ADR in the United States is interesting. Mediation is common here. It's always for at least as long as I've been here, common. I think that's because, you know, most disputes in the United States, people approach them with a view to settling. I don't think most commercial clients want to go through the time and expense and risk of a jury trial, which is a bedrock feature of the US system. You'll sometimes hear people in the US say, oh, 95% of disputes settle. I think that figure is much too high. I think that's a kind of anecdotal figure, but I do think the majority of disputes settle, and many of them do settle by way of mediation, which is very common and which is actively supported by both federal and state court systems here. So I think that is going to continue to be popular in the future, and also for two reasons. I think first of all, clients will want to continue to be able to settle their disputes. I don't think that's going to change anytime soon. The second reason is, as companies still figure out what the impacts of the pandemic are and its effects continue to be known on the bottom line of businesses, I don't think corporations are going to be wanting to pursue litigation and tie up their capital in you know, pursuing a long jury trial or a long arbitration to fruition if they're able to settle it by way of ADR mechanisms. And so I think that savvy corporations and savvy lawyers are going to want to continue to have mediation as a tool in their toolbox. I don't think other ADR mechanisms more broadly are as popular in the United States. Conciliation, for example, I think is very seldom used. I think most clients don't view it as having much to offer over a combination of mediation and arbitration. Many would view it as kind of a non-binding form of arbitration, so double the expense without much more benefit. But I do think there is a strong future for mediation into the future.
Right. Thanks, Justin, and congratulations on your pastry journey. What's your specialty?
Oh,
I'm
a specialty. I don't know that I have one, but I made a babka on the weekend, which was a fusion between kind of the Eastern European babka and the kind of Chinese scallion pancake by having a scallion babka. So
nice.
There you go.
Nice. So going back to Darius, apart from what Justin just said about the benefits of mediation, what are the main strengths and weaknesses of mediation or negotiation over other means of dispute resolution, especially arbitration?
So as Justin just said, I think to me the key strength of mediation or negotiation has to be the preservation of commercial relations. I think that's the top attraction. And typically in arbitration, as we all know, it's a winner-take-all situation. Party A pays Party B, subject to any counterclaims or sell-offs, right? But in a mediation or a negotiation setting, parties can explore resolving the dispute in much more commercial ways, exploring whether it's possible to involve each other in other transactions, other projects, structuring a particular payment scheme, involving payment in kind, etc. I've seen all kinds of creative ways of resolving disputes in a mediation setting. On the flip side, however, the weakness of mediation, this is more interesting to me because in my view, it's not so much the difficulties of enforcement, because typically in mediated settlements, parties having devoted time to craft the mediation outcome would typically adhere to it, in my experience. What I see as a practitioner is clients typically think that the party who suggests mediation first will be perceived as having the weaker case on the merits. Yeah. So there's a strong tendency, inertia, I'll call it, to not be the first one to say, hey, let's mediate. So unless mediation is hard-coded into the dispute resolution clause, sometimes there's a lot of posturing before we get to the mediation table.
Right. And Kirsten, do you share Darius's view?
It's definitely on point. And I think that's why the SIAC ARB protocol is essential in a sense, because it kind of facilitates mediation in the process without any side having to feel that he's showing a weakness in the case by initiating mediation. I would also add perhaps that one of the strengths of mediation is that parties can reach creative and mutually beneficial settlement outcome. One thing I always remember from my mediation days at the Hong Kong University is this orange peel and orange fruit analogy. It's finding out what the interests are really of the parties. And perhaps like one side might prefer the orange peel and the other might prefer the orange fruit itself. And actually, that could be a win-win solution to be gained through mediation. But until we reach the point where we really know what the interests of the parties are, it's hard to reach a mutually beneficial outcome. So I think mediation has definitely a good influence in that process. And I think one of the other weaknesses of perhaps using other forms of mediation or negotiation, ADR mechanisms, is that I've seen this unfortunately play out where it could be used potentially in bad faith, in the sense that it could be used as a means of delaying arbitration or litigation, or for purposes of digging out information that may prove useful to one side in litigation or arbitration. It's unfortunate, and that is not the intention of mediation, but I've also seen it play out sometimes. So that's not to be encouraged, not at all, but I do think that having it as part of the process, like the ARB-MEDOP protocol, might help.
Thanks, Kirsten. Because Kirsten mentioned SIC's ARB-MEDOP, and for the benefit of our viewers that are not familiar with ARB-MEDOP, briefly, it is a procedure that SIC made after teaming up with the Singapore International Mediation Center, where parties are able to file or commence arbitration, and SIC will quickly constitute a tribunal. The tribunal will suspend the arbitration proceedings and pass the records of the parties to the SIMC, or the Singapore International Mediation Center, give the parties time to mediate. I think it's about 8 weeks. If they end up with a mediated settlement, then the settlement agreement can go back to SIC. There's a constituted tribunal waiting to issue a consent award, which, as we all know, can be enforceable under the New York Convention. But if the parties do not end up in settlement, then at least you don't lose time and you have an arbitrator sitting and ready to hear the case. So that's just a brief overview of SIC's ARB-MEDOP. Now, turning back to our viewers, what are your key priorities in your arbitration wish list? And please help us learn about this based on your views. And the poll question is on your screen right now. Are the speakers able to see the poll questions? And okay. Okay, I think we're done. So the key priorities, I'll read the top 3. First is introducing procedural innovations in the institutional arbitration rules. Okay, that's interesting. And just a little plug, SIC will be revising its rules very soon. So if you have any comments or suggestions, please feel free to email us. Kevin Nash, our Deputy Registrar and Center Director, is leading that exercise. The second one is providing more opportunities for younger arbitrators to arbitrate cases. Okay, that another plug. SIC has a reserve panel for younger arbitration practitioners. So also please feel free to get in touch with us if you want to apply for a reserve panel. And the third one is lower costs of arbitration and less time taken from the filing of the arbitration request to the receipt of award. Hi. Okay, that's very interesting. Thank you. Thank you so much for answering the question. Now I'd like to move on to Justin and ask him whether arbitration versus mediation, whether that's a false dichotomy. And what is your opinion on ARB-Med-ARB and mediator and reserve models, for example?
Thanks for the question. I definitely think that it is a false dichotomy. I think that they are both tools designed to reach an outcome. They're both designed to quell controversy between two parties. And I think that they're complementary in many senses. They're not mutually exclusive. You can use both at the same time. And I don't think kind of drawing a distinction between the two of them in a kind of dichotomous sense is holds up. On my opinion on ARB-Med-ARB, I think it is very useful to the point that Darius made. It's useful to the extent that it eliminates the kind of first mover weakness issue where one side is perceived as being weak or lacking confidence in their claim because they try to approach the other side in order to try and mediate the dispute. The other advantage is, of course, if you do reach an amicable settlement in the mediation, it can take the form of a consent award, which most would consider enforceable under the New York Convention. On the other hand, I would kind of make 2 points. The first is most institutional rules already provide for an agreed outcome to be issued by way of consent award. It doesn't need to be by way of the ARB-Med-ARB clause. So to the extent you view kind of the enforceability aspect as the advantage, the counterpoint would be, well, you can already achieve that, through YSIAC Rule 3210, for example. The other downside that I see thinking about it from a commercial client perspective is most clients, I don't think would like to find themselves in the position where they are bound to mediate for a set period of time. I think that they would want the possibility potentially to be able to get out of it if, for example, the mediation proves futile, if, for example, the relationship has already irreparably broken down, if, for example, they don't think it's the kind of dispute that is going to reach a negotiated outcome. Being stuck in mediation for 2 months while the arbitration is stayed has the potential to slow down the resolution of their dispute from their perspective. And especially when kind of one side might not be approaching it in bad faith and simply using it to run the clock in a kind of a dilatory sense. I see that as a disadvantage. And I think many clients would ask us, well, if I have just a plain arbitration clause, the YSIAC model clause, wouldn't I be able to try and approach them for mediation anyway? And the answer to that would be yes, of course. But it would have the attendant risk that, well, not the attendant, it's not a risk, but the attendant issue that Darius has identified about first mover. On mediator and reserve, I'm not sure if you asked me about that, the idea that as soon as an arbitration is commenced, there is a mediator in the wings waiting to go. Should the parties decide that they want to do that. I think that's interesting. I don't think that there has been much uptake of that. I think it might be a unique feature of JAMS in the United States. Other institutions may have it. I think that ultimately, if companies want to mediate their dispute, I don't think it's going to matter a whole lot whether or not there's a mediator in the wings. I think that they will get their mediator if they want to be able to mediate their dispute. But to the extent that it brings the prospect of mediation front of mind as an option, as a solution, then I think that that is a positive development that should be encouraged.
Thanks, Justin. Sam, your views?
Yeah, I agree with what Justin said. On the mediated in reserve model, I'm not that familiar with it because, as Justin said, I think it's a JAMS feature. The one reservation I think I would have with that model is sometimes you want to choose your mediator. I'm aware that different mediators take different approaches, and we've had very active, proactive mediators who really go above and beyond to help parties reach a settlement, even when throughout the entire thing, everyone is saying, this is not going to happen, I'm not going to agree. So you might want to choose the appropriate mediator at the time you're entering into mediation. So I'm not so sure about having someone just at the beginning. On ARB-Med-ARB, I tend to agree as well that having a set mediation time frame within your procedure might lead to delay. And so it's good to have the option to mediate. And I think it's really on us as counsel to raise the prospect of mediation in a dispute where we think this case properly is suitable for resolution by a mediation. And I just want to make one point about the false dichotomy. I think there is a fundamental difference between arbitration and mediation, which is that one procedure gives the parties control over the outcome, whereas the other does not really. In a mediated settlement, as Kirsten, Darius mentioned, you have the flexibility to formulate your own solution that both parties can agree to. And sometimes clients like that because they can account for some amount or something in their books where they say this is the exposure because, you know, I've decided on it through a mediation, I've cleared it with my CEO, as opposed to going through an arbitration and then waiting to the end, you know, at the edge of our seats thinking, is it going to be 0 or is it going to be 100 million? So that's one of the most useful features of mediation, I think.
Okay, thanks, Sam. Sam, still with you. Do you think there is a uniform international arbitration practice? Does arbitration look and feel different in Singapore from the US?
Very interesting. So I'm not going to attempt to answer this question. What I'm going to do is tell you how I see arbitration and how I think my clients see arbitration. And then I'm going to let Justin tell you how he and his clients see arbitration from the US perspective. And then we're going to have some fun, I think, hearing each other's perspectives and comparing and contrasting. From the Singapore end, I sort of view arbitration as something that is used in commercial disputes. So not criminal, not family. And I also consider arbitration to be the dispute resolution forum of choice for our clients for cross-border commercial relationships. And this is especially the case when one counterparty is based in a jurisdiction where the courts can be quite unpredictable. I say that sitting in Singapore because I think, given the Singapore courts, if you have a dispute between two Singaporean parties, it's really fine to go to the Singapore courts. It's fast. And I think the court fees are cheaper than the arbitration institution's fees. So when it's cross-border, then yes, absolutely, I think it's the preferable choice. And I think our clients recognize that now. They quite readily use arbitration YSIAC clauses in their contracts when they're contracting cross-border. I think Adi asked how arbitration looks and feels from a Singapore perspective. How it looks, I think I would say it looks to me like lots of people in an unnecessarily cold hearing room for days. This is my picture of arbitration. It describes the hearing, which I think is the culmination of a proceeding. And to non-participants, it just looks like a meeting. But yeah, I think that's a pretty unexciting picture of how arbitration looks from my perspective. And how it feels, I would say, well, first of all, cold, right? Because of the strong air conditioning in Singaporean meeting rooms, and I'm told next door chambers as well. But I also think arbitration tends to feel delocalized. It's somewhat intangible, it's floating around. You don't have a court building to which to attribute it. But this happens all the way until you have the paper award. And on that basis, when the client receives funds into its account or local court grants enforcement, then you get some kind of form to an arbitration. That's how I see it.
Justin, what do you think?
I think for a number of US clients, international arbitration is not their first port of call. I think that there are a lot of major US companies that find themselves very seldom in international arbitration. I think that their default frame of mind is US civil litigation system, I'm going to be entering into contracts with people around the world. They can submit to the US courts, the courts of Delaware, for example, if it's a commercial dispute, and we'll resolve it there. So whilst most US companies will be extremely familiar with civil litigation, not all will be familiar with international arbitration. And so I think that the way that they perceive it is without necessarily, I think a way a number of companies perceive it is without a great sense of familiarity. It's not a familiar mode of dispute resolution for them. And so I think that the way that tends to play out is by noticing the absence of certain features of civil litigation. You'll do a hearing and they'll say, oh, there wasn't many objections, or you won't take depositions, you won't serve the other side with interrogatories, and it's all very civilized. And so I think that it's often the absence of features that stands out. In terms of kind of a convergence of practice, having done arbitrations in Singapore through YSIAC, having done them in the US, I think there is a convergence in practice. I think for the most part, they have a general formula of, there's the originating process, some sort of request for arbitration response, tribunal constitution, some sort of written phase, some sort of oral phase, some sort of award writing phase. And I think in many respects, there is a convergence in practice. I haven't noticed a whole lot of difference between US and American arbitration. That in many respects, it's a lot of the same people from those jurisdictions involved in major arbitrations. So that's what I would say.
Yeah. How about the difference in Singapore common law versus US common law practice? And perhaps we can start with discovery. Sam, could you discuss the controversial Section 1782 for US style discovery?
Oh, yeah. So on that question, on the difference between Singapore common law and US common law practice, I want to start with talking about something exciting, which is, I think, an instance where the two practices potentially marry or converge. And this is Section 1782 of Title 28 of the United States Code. It's a tool used in a US court proceeding, so you would have to go to a US court. But it's a tool where you might, I'll come back to explaining why I say might. You might be able to use this section as a tool to obtain extra discovery in an international arbitration. This procedure allows a party to go to a US court and ask for an order that a US person or entity give testimony, so a deposition, as Justin mentioned, or produce documents for use in a proceeding before a foreign or international tribunal. I've used these words, proceeding before a foreign or international tribunal, advisedly. So, and here I come to explaining why it's only a potential possibility. Some US appellate courts have interpreted these words to include international arbitral tribunals. And on that basis, parties have gotten extra discovery from US parties in support of international commercial arbitration. That said, the issue is now before the US Supreme Court, and so the final position on this section has yet to be established, but we should all stay tuned and bear this procedure in mind were we in a dispute in arbitration overseas that involves some kind of US party from whom we might want discovery or depositions.
And Darius and Justin, please feel free to jump in on the difference of Singapore common law versus US common law practice. I suppose I'll start with Darius for your Singapore point of view.
Yes, sure. And practitioners, at least in Singapore and Hong Kong, we would know that we don't have the kind of deposition style taking of evidence that Justin just mentioned, right? And certainly the scope of discovery is well known under the English system. It's not as far-reaching as the US system. But leaving that aside, in the arbitration setting, all arbitrations that I've done will involve the Redfern schedule and the IBA rules, right? I've not seen a tribunal saying, no, we're going to have the US style discovery or Singapore style discovery or civil law discovery. It's always been the IBA rules. So to that extent, I think there is a convergence in arbitration, and that surrounds the IBA rules and the use of the rate firm schedule. I do not want to be saying that, I do not want to be seen to be saying that the rate firm schedule is the best. I don't think it's the best way of handling discovery applications, there's disclosure obligations. It's cumbersome, the table doesn't work, the landscape form, it just doesn't read properly, it's clunky. There's a lot we can do about it, but the point is that regardless of the differences between the two systems in arbitration, we do have a convergence.
Justin?
I'm looking forward to the Chan schedule of discovery to replace the Redfern. I think, I agree with all of that. I think the Section 1782 issue is going to be a very hotly watched one. And, you know, a lot of people are waiting to see what the Supreme Court says about it, because at the moment you've got kind of a circuit split amongst US federal circuit courts of appeal. And so you can get it in some circuits, but you can't get it in others, which I think encourages over the long run things like forum shopping. So I don't have much more to add to that other than, you know, I think we were going to talk about third-party funding. I think as that just as one example of what's available at common law. You know, there are exclusions on it at common law around championing and maintenance. I think that Singapore's done away with those. US has done away with those, at least in New York. It is a state-by-state issue because third-party funding, for example, is not dealt with in the federal statute governing arbitration, the Federal Arbitration Act, and so it's left up to the states. But I think most major states of commercial jurisdiction, you know, New York being one example, permit it in claims over $500,000, which kind of, I think would be the minimum if you're talking about third-party funding anyway.
Right. Sorry, Darius, you wanted to
Yes, I was just going to say that in Singapore, we've abolished, and Hong Kong, we've abolished the torts of championing and maintenance that Justin mentioned, but only in relation to arbitration and related court proceedings. We've not gone all the way to abolish the torts. But how it plays out in practice is that a US-based client or Korean-based client would typically expect some kind of contingency arrangements, but for those of us operating in Hong Kong or Singapore, we cannot offer the same. But very recently, then this might be of interest, very recently, both Hong Kong and Singapore have announced potential reforms to allow outcome-based fee structures, right? Going beyond third-party funding to outcome-based fee structures. So this is certainly a space to watch.
Right. Thanks.
And that is a divergence because they're not, they are permitted already in the United States. Most jurisdictions permit contingency fees.
Yeah.
Mm-hmm. How about in terms of disclosure or confidentiality? Is there any difference? Yeah.
I think there is a difference in confidentiality, as I understand it. England and Wales is adopted the approach of implied duties of confidentiality in arbitration, which was taken up by the Singapore courts in their common law. In the United States, there is no implied duty of confidentiality in arbitration. But I think the way that that resolves itself mostly in practice is that parties agree to a reputable set of institutional rules that includes a confidentiality obligation, or on the other hand, they just simply contract for it in their arbitration clause and provide that the procedure and the process will be confidential.
Darius, do you have any?
I was actually, sorry, just one point on that. I was actually surprised in the poll that confidentiality didn't rank a little bit higher. I was surprised that people in the audience put the ability to select arbitrators as higher than confidentiality. That surprised me. I actually would have thought confidentiality would have been second after enforceability. I suppose that also would differ if the question had distinguished between investment arbitration and commercial arbitration. I think that would have maybe had quite a difference as well.
Right, right. Darius, any further comments from Singapore's side?
Not for me, just in summing up perfectly. We recognize the implied duty of confidentiality. So Justin nailed it.
Thanks. So now let's move from the substantive to the day-to-day practice. And some of our viewers might be students thinking about which area of law they would like to practice. So Justin, what is your day-to-day like as an arbitration practitioner in the US? And then I'll ask Kirsten and Sam as well.
My day-to-day, I think it depends really. I think it depends on two things. First of all, what stages your cases are at. And I think the second thing it depends on is how senior you are. So what I'm doing now is very different to what I was doing 10 years ago, 8 years ago. For now, if I'm not in a hearing, I'm usually usually get up to many emails from Asia and Australia, where I do a lot of my cases, because of the time zone, and you wake up to 50 emails and think the sky is caved in, but just another day in the shop. Usually answering those, working with experts or witnesses to help them prepare their evidence, updating clients or getting instructions from clients on things that need to be progressed, and just managing the file. If we're preparing for a hearing, it's usually all hands on deck. It's preparing the closing or opening arguments, the outlines for cross-examination, and attending to the 1,000,001 things that you don't think require organization, but actually require organization. It takes time to resolve all the hearing logistics down to, how's the chess clock going to work between the parties, and all of that takes time to work out.
Right. Kirsten?
I was going to add that I do the same as Justin. Even though I'm based currently in DC, a lot of my clients are based in Asia. So my mornings and evenings are for clients and taking instructions and communications. Business development is one aspect in my current situation here in the US. But I like the international practice of arbitration. I think that's what makes it interesting. And in the afternoons, I would reserve that for drafting. So actually doing the submissions and memorials in the afternoon and on the weekends. But that's the beauty of arbitration. One thing I also do is I do take inquiries as well when others are seeking information about arbitrator appointments, because as globally the ambassador of arbitrator intelligence, and people are looking for information on arbitrators, it's part of my role as that ambassador to lead them in the right direction, and to see arbitrators who are suitable for certain cases and maybe speak certain languages. So I would say it's a pretty full day, and every day is different, but that's what's exciting about practice.
Sam?
I was going to say, I usually start off my day from my living room, speaking to an audience from 20 global jurisdictions. But no, that's not the case. This is a rare one-off day. But jokes aside, what is relevant is this international element of the practice of arbitration, as Kirsten mentioned. So I would divide up my practice into kind of 3 categories, and each of them has an international element. The first is doing the work, the day-to-day work, and Justin described it perfectly. Emails, responding to questions, dealing with logistics, things like that. So, that's probably the bulk, I think, of our practice. Research, drafting, thinking, mostly in your office. The second category of our work is where the work is brought to life. That's how I view it. And that would be a hearing, most importantly. I think that's the climax, the culmination of each case. And that's really the fun stuff. Of course, you don't have a hearing all the time. And so even, I think, at least in this part of the world, panels like this and meetings with people really allow us to bring some kind of human element and life to the work that we're doing, where we talk to people about it. And the last aspect is camaraderie. There's a lot of this in a disputes practice, and I found it with the team I work with in the arbitration team. And there's also a lot of camaraderie in the arbitration community, and I think this is quite global, because of the international nature of it. We're having this panel now where we're talking to Kirsten in DC, Justin in New York, and this is just a daily occurrence where you're talking to people from all over, and that's really fun.
Thanks, Sam. Going back to Kirsten, we almost lost you to Singapore Airlines earlier. So what about arbitration are you passionate about, and why did you choose arbitration?
Right. I must add that in the end, Singapore Airlines was one of our clients in the firm. So it was like coming back home in a sense. So what about arbitration I'm most passionate about? I think there are two aspects to this. One is, as Sam and Justin Darius have also shared, is that we get to meet and work with arbitration practitioners and stakeholders in the community worldwide. Like we speak with practitioners in Europe, Africa, LATAM, Asia. It's very meaningful and a great community worldwide. And I think, I do not think that there's any other practice that allows us to do this. The second aspect I find most enjoyable is that we get to innovate in arbitration. Moving from big law to boutique, I've had to generate technology, right? I've had to harness technology to help me with my work, being extra efficient, and that I find most enjoyable, like innovating in arbitration to enhance the status quo. So I'm currently, for instance, developing an arbitrator appointment toolkit to ensure that all factors go into the consideration as to what arbitrators should be appointed. I'm also working on blockchain arbitration protocols. And in particular, I'd like to shine a light on the black hole surrounding arbitrator appointments. So there are more than 100 ambassadors at Arbitrator Intelligence. We work together because we share in the values of diversifying and broadening the arbitrator pool. And we also want to increase transparency and accountability in the arbitrator selection process. And when we get objective data on arbitrators' profiles and their performance in past cases, like we have a more informed, decision to make when we are thinking of which arbitrators to appoint. And I feel that, this probably comes from my time in Scandinavia and perhaps some places in Europe and Asia. For many institutions, I think, and there's also ad hoc arbitration, but for some institutions, they do not really have a publicly available list of arbitrators. So if you had a case in these institutions, where do you look when you're looking for an arbitrator? There's no publicly available list. And even if you did, do you know the names on the list? So how would you then go around shortlisting or recommending any of them to your clients, right? So I find that there is a lot of meaning in what we do in trying to diversify that and increasing information, access to information when it comes to arbitrators. And I was really not surprised, I must say, when one of the poll results showed that we'd like to see more younger, up and coming, bright, intelligent arbitrator, get appointments. How do we make that possible if a young arbitrator is very, very excellent in his performance, but he has not had a case?
Right.
It's a chicken and egg dilemma. But
Right.
if you had data on how he performs in past cases as counsel or as arbitrator in ad hoc cases, for instance, that might actually be a good starting point to enable younger practitioners to get their first appointments and the second and the third. So I always say this, we believe that there is a Gary Bohn or Gary Bohn Jr. in every town, in every city in the world, right? It's just that perhaps there is not a lot of information about the brightest and the young arbitrators around the world. And so that's what I find really meaningful in the arbitration practice. So yes, if I could sum up, those are the 2 points.
Thanks, Kirsten. We're running out of time, and I just want to address a few questions from the audience. And I think we've touched on this earlier, but probably we should elaborate. So the first question is, does Singapore have a similar discovery provision to aid in arbitral proceedings? So anyone can just jump in and answer this question.
I think by similar, the question means similar to Section 1782. And I think the answer is no.
Mm-hmm. Okay. Go ahead, Sam.
Oh, I mean, it's no.
Okay. And because you discussed this earlier, so just to elaborate, why are the U.S. Circuit Courts split on allowing discovery to assist arbitral proceedings? Can you frame the issue for us?
Okay, I haven't been following all the decisions all that closely, but as I understand it, the dispute is really about the construction of the phrase, and then you look for it, foreign or proceeding before a foreign or international tribunal, and the intention behind that phrase. There is an argument that that phrase really means foreign tribunals like the ICJ, for example, and is not meant to apply to foreign commercial proceedings. And I can see some reason for that argument. really, the procedure allows you to apply against a US person or entity who isn't even a party to the arbitration for documents. So just by virtue of the fact that there's some relation to the ongoing commercial arbitration, and the fact that this entity is based in the US and has documents of interest, this tool is arguably being used. There is possibly some conflict between that and the idea that arbitration is a consensual proceeding between two parties who have agreed to participate in that procedure.
Thanks, Sam.
And if I may add, I think please keep a lookout for the US Supreme Court case, Servertronics and Rolls-Royce, which is on this question. So essentially, in a snapshot, some appellate courts have ruled that Section 7882 does authorize discovery, and some have said no. So this issue is before the Supreme Court for a unifying decision. So please stay tuned.
Well, thank you. Thank you so much, Kirsten. Unfortunately, we've run out of time. I really enjoyed this session, and I hope you did too. On behalf of the YSIC committee and the CIArb YMG, we would like to thank our panelists and viewers for tuning in. To those who are not yet members, again, we invite you to join us. Thank you very much, and we hope to see you in our future events. Have a good day.
Thanks very much.
Bye.